Yes, Ms. Muncherin.
Your Lordship asked a question before you read to the effect that whether by taking the option, defendant number one, that is respondent number one in this case, prevented the fulfillment of the condition suspensive.
Yes, that's the first stage, and if so, is the consequence that there is either a waiver of the condition or it's deemed to have been fulfilled.
I would submit, my lord, that the option and the undertaking are two different things altogether.
The option and the
option taken by the respondent number one in April 2010, and the undertaking, that is the undertaking which was signed on the 18th of April 2006, are two different things altogether. And that by taking up the option in April 2010, she could not have prevented the fulfillment of a condition. And here I will refer your Lordship to the judgment of the Court of Civil Appeal at page 378. Line 31.
Did you say 378?
378.
Thank you.
Page, paragraph, it's the last paragraph, in fact, line 31. As I stated earlier on, the option and the undertaking are two different things altogether. And this is what the Court of Civil Appeal found.
Yes.
Thirdly.
That's perhaps not a complete answer. If we take it in stages, was the suspensive condition requiring the Ministry's consent to an assignment of the lease, was that still in operation in April of 2010, or had it lapsed?
In this connection, my Lord, I will invite your Lordship to look at the agreement itself, the undertaking. I will have to go through the undertaking and explain how it lapsed and when it lapsed.
Yes, and also whether Mr. Glover tells us that a condition can't lapse by itself, yes, unless it becomes impossible of completion. The Code Civil caters for that. But otherwise, you have to make an application to the court if the argument is simply that such a long time has elapsed that the condition should no longer be binding.
But your Lordship will note that the appellant lodged her case on the 23rd of October 2007.
Yes.
18 months after the undertaking, and soon after, the respondent gave a defense at page 64 to say that, and this is line 10,
yes,
but line 10, 11, the defendant further avers that as far as she is concerned, the promesse de vente can no longer stand good. But instead of respondent number one lodging the case first to declare the sale void, unfortunately in this case, the appellant decided to lodge the case to ask for a perfection on it. Mm-hmm. And then the respondent number one came up with a defense that I cannot be bound ad vitam aeternam, which is true. So anyway, if she had lodged an action together, there would have been a cross-action. There would have been a cross-action on her part, and she would have raised the same defense as in the plea, in the court below. And we should not forget, my Lord, that there was no exit clause in the undertaking signed between the parties. Yes. How could she have then gone to court and said, I want the undertaking to be declared void? I will here refer your Lordship to a French case.
Sorry, just before you do that, so your submission is that the undertaking continued?
My submission is that she could not be bound ad vitam aeternam, and at some point in time, the undertaking had lapsed.
And at what time? What time do you say it
And the
lapsed?
time would be a reasonable time. This is what the courts have to say in France, have decided in France. And I'm going to refer your lordship to the translation, which was given this morning. Page 13. The translated version is at page 13. This is a judgment.
Our pages aren't numbered, so there's a little moment.
It's paragraph 149, my lord. 149.
Of the translation.
Is this reference to a decision of a Cour d'appel de Montpellier?
Yes, my lord. Exactly. And this is what the court...
Just one moment.
Yes.
I'm very sorry. In the translation.
What is this document?
And it's about 5 sheets into it. About 5 sheets in, the bottom of the page.
Yeah, I've got it, but what's the translation?
Oh, well, it's a head note of a report of a decision in 1948.
Well,
the head note reads thus.
There is the French version.
Paragraph 149, I think, this is a replication of 149 of the respondent's case, which then pleads, which then sets out in French citation
Right.
to the authority. So this document then will be translated.
Oh, I see.
got it. Thank you very much.
4 or 5 sheets in, begins at the foot of the left-hand page.
It's written page 4 or 5 at the top.
Thank you.
Yes, it's page 4 or 5 of the
Yes,
translation.
Exactly.
And I'm sorry, Mr. Casey, the paragraph in the
149.
respondent's case, 149 again.
Paragraph 149 of the case,
Yes.
where you have the French version of the citation.
Thank you.
Yes. And this is what the courts had to say as far back as 1948. And this case was applied in Mauritius in the case of Tamarind Falls, which I'm going to refer later on to your lordship.
So your submission is whatever amounts to a normal and sufficient time in the circumstances?
Yes, reasonable time.
A reasonable time.
When the condition is subordinate, this is what it says. In a case where the occurrence of an obligation is subordinate, like in our case, to the realization of a condition suspensive without any delay, like in our case, having been agreed to realize that condition, it implies that the parties not being indefinitely bound to search what was the common intention. Then, when the condition is subordinate to an authorization of the authorities, like in the present case, the parties, after the normal and sufficient time to obtain the authorization has lapsed, can consider that the condition cannot be realized. Because it is impossible.
And this, in fact, is the authority cited for the proposition we looked at earlier in the Mauritian case of the Nouvelle Société de Tamarind Falls.
Yes.
Yeah.
Yes.
Right.
Does this apply where the contract is, as it were, one-sided? In this case, there's a time limit, which the expiry of which enables the purchaser to walk away.
There was a...
But it's silent as to the ability of the vendor to walk away.
Exactly, my lord. Exactly, my lord. There was an exit clause for the appellant 15 days after, if the authorization was not forthcoming after 15 months, she could exit from the agreement.
But my question to you is, I mean, I don't know what the agreement in the Montpellier case actually said. Indeed, I don't even know whether the civil code to which that case relates had the same provision in it as Article 1176. But putting that on one side, it's a readily understandable interpretation where the contract is completely silent. In this case, you've got a sort of one-sided provision.
Exactly, and this is what we submitted in the court below, that it was one-sided. And I'm going to refer your lordship to the case of Tamarind Falls later on to explain that even if it is one-sided, the court can consider that the condition had defied after a lapse of time.
Right.
And the case of Tamarind Falls is on all fours, except that in that case, it was the vendor who lodged the case.
Well, it might be a good idea for us to look at
Yes.
at that case.
says at tab 12, my lord. Tab 12. In this case, there was an agreement in December 1972 where the parties agreed, they signed a deed that the defendant was to purchase some 180 acres of land to be distracted from a larger portion. And in this connection, the authorization of the relevant authorities was very important. It was a condition suspensive, a court held.
And we've seen that sort of condition here
Yes.
quite recently. That's where you have to get planning permission to subdivide the land.
Exactly, my lord. And in this case, fourth paragraph of the judgment, fourth paragraph in the first page, unfortunately, it's in French, the deed is in French, but it says that if after 3 months the authorization was not granted, the purchaser had the option to back out. But no such exit clause was catered for the vendor, exactly like in our case. What is more, my lord, and I'm referring to the
Just a moment, just going a little bit fast for me. I'm just looking at the condition. So it's expressly agreed between the parties as essential conditions of this agreement, but in the event that the Development Bank of Mauritius, within 3 months, counting from today, hasn't accepted the delegation of the above sum of 75,000 rupees, etc., and or that the competent authorities haven't authorized the present division harcèlement.
Yes.
These presents, this deed in other words, will be considered as null, and that solely by reason of a failure to obtain the authorization within that time limit. Si bon semble à la compagnie acquéreur.
Exactly,
Right.
exactly.
Okay.
And it was si bon lui semble. It was for him to decide whether he wanted to go forward or back out. He had an option. Even though the authorization was not granted, he could still stay in the agreement.
Yeah.
And there was no exit clause for the vendor. And at the next page, which is MS 696, paragraph 2,
Yep.
the plaintiff, in its statement of claim, averred that the obtaining of a morcellement permit was a sine qua non condition suspensive, and that as the competent authorities had not up to that time failed to grant the permit, the agreement had become null and void and should be cancelled.
Now, who was the plaintiff? Was that
The plaintiff was the vendor in this case.
right? Okay.
Sought an order compelling the defendant to return the land.
Yes,
The land-
because the land was given to him for him to enjoy at that point in time. So even though he was given the enjoyment of the land, we'll see later on that the court declared the agreement void.
Yes.
And there was a payment of 55,000 rupees, which was given to the vendor. And in the statement of defense, next paragraph, they averred that it was within the sole province to decide whether or not the failure of authorities to grant the permit would entail the nullity of the agreement.
Yes.
So again, they came up with that defense. No, you cannot back out because this is my prerogative. Moreover, inasmuch as it had not been established that the authorities had refused to grant the permit, and that in any event it did not propose to avail itself of its alleged sole right, and in this case the purchaser didn't want to avail itself of that right to back out. And then This is
There's
what
been
we
a
see.
threat of legal proceedings against the ministry, I see. Bottom of page 696.
I'm sorry, my lord?
I'm just looking at the bottom of page 696.
Yes.
There'd been quite a lot of effort to get this condition, this permit, including a threat of legal action against the ministry concerned.
Well, is that?
No, it would take
What is important, my lord, is page 700.
700.
Yes, 1, 2, 3, fourth paragraph. MS, page 700.
Yes.
Yes. This is what the court says, but this does not dispose of the matter. We must look a little closer at that part of the condition, which in effect says, even if the authorities refuse to authorize the morcellement, the would-be purchaser would be at liberty to decide whether the agreement is to be treated as null and void, and this necessarily implied to compel the owner to sell. This is clearly a condition illicit. In this case, my lord, if we look at the prayer of the plaintiff, the case again was lodged on the 23rd of October 2007. We know that at that point in time, the vendor had not taken the option. Yet, the purchaser is asking the court, declare that I am the owner, although we know that the authorization had not been given. So he's asking the court to declare that I'm the owner when we know for a fact a very important condition was not materialized at that point in time. How could she have been declared the owner of the land? And again, this rejoins the case of Tamarind Falls, where the court says thus that this is illicit because it would tantamount to enabling the defendant to compel the plaintiff to commit, in this case, a criminal offense. But in our case, we would say an unlawful act, because we know for a fact that the authorization is mandatory. And you know, the purchaser knows, as at the 23rd of October 2007, the option had not been accepted by the vendor.
But matters had moved on by the time of the trial before the judge.
Yes. And then, if I may finish with this judgment, my lord, and finally, page 703, 702 first, 702, last paragraph, before quoting the French cases, second line, we accordingly hold that at the time it entered the present action, the plaintiff was entitled to treat the agreement as being at end, as it became obvious in this case that the condition was not materialized. And then they refer to the cases which was referred to by the trial court.
I'm sorry,
I'm lost. Where is that?
where was
This
that?
is at page 702,
Footnote.
last paragraph.
Last paragraph. What's it?
Second sentence.
There used
It
to-
starts with moreover. Yes, my lord.
there came a point in time
Yes.
where the refusal of the authorization could be implied.
Yes.
The fact that nothing had been done.
Yes, my lord. And we must not forget that the agreement was signed in April 2006. As at April 2010, 4 years had lapsed. There was no authorization for 4 years.
Mm-hmm.
So can the vendor say, I'm going to be bound for 4 years? Would it be fair when we know that the purchaser has got an exit clause after 15 months?
Yes. And so you would say, applying what was said by the Montpellier Court of Appeal, there had flowed a normal and sufficient time to obtain the authorization.
Yes.
Yeah.
And lastly, I'll refer to page 703, the last paragraph, where they make their finding.
Yes. And if they're
Findings.
entitled to treat that, I mean, the way the court in Montpellier put it was that in that situation, they can consider that the condition will not be fulfilled because it's impossible. So does that mean that they're then in the position envisaged by Article 1176
Yes.
of the Mauritian Code Civil?
Yes, my lord.
Right. Okay.
And then last paragraph is very
So the
important.
implication of that is you don't require a court order.
No, Our submission is that we don't. No. Because if we were to lodge a case, what would we say? We would say the condition has not been fulfilled within a reasonable time, except that there would be a court case. But in this case, since the purchaser lodged its case before us, we took it in our defense, that we could not be bound ad vitam aeternam. And then the last paragraph is very important, my lord, page 703. We accordingly hold that, in accordance with the manifest intention of the parties, as one of the essential suspensive conditions. We are again dealing with authorities, ministries, like in our case, a third party.
Yes.
Of the agreement has not material. The parties thereunder must cease to have effect, and we declare accordingly. We order the defendant to restore the plaintiff in possession, described in document A, not later than 30th of June, and then to reimburse the sum of 55,250. So even if he was in possession of the land, the court said no. Even if you were in possession, it doesn't matter. The person cannot be bound ad vitam aeternam. Reasonableness should apply. Fairness should apply. You've got 15 months. I can't be bound for life. So in this case, they said that it would be only fair to declare the sale void after a lapse of time had elapsed. And this, I would submit, this case is on all fours with the present appeal, my lord. It is important to note, my lord, that even the trial court, at page 158, last paragraph, line 31.
158.
Page 158, last paragraph. First line, it would certainly have been preposterous to keep the defendant tied up for an unduly long time after the authorization administrative had been sought and were not forthcoming. And then we have also the case, we know for a fact, my lord, that an injunction was lodged by the applicant in this case in July 2007. Because the vendor had leased the property, although we know for a fact that there was no clause in the agreement preventing her to do so. And then this judgment went on appeal, and I'm referring your lordship to page 200 of the judgment of the appellate court. It's a judgment of the appellate court. Last paragraph again. This principle of not being bound ad vitam aeternam was again set out by the Court on Appeal, page 200, last paragraph. While it is a correct proposition that appellant cannot be bound for life to maintain her undertaking to sell the premises to respondent if no approval is forthcoming, it is in this case, they didn't raise the defense of conditions suspensive, but the same principle was set out by the Court on Appeal. I will now, with the permission of the court, take your lordship to the undertaking. Either we call it undertaking or the agreement, which was signed between the parties. This is at page 173, the French version, English 502. Translated version.
173.
173, the French version, and 502, the translated version.
Yes.
In this case, we know that the agreement was not signed by the purchaser because she was not in Mauritius. It was signed by the brother, Mr. Sohan Angteeah, the proxy.
Yeah, it may be helpful for us anyway to note, in the case you just took us to, the one about Cameron Falls,
Yes, my lord.
at page 702, I may just be catching up with everybody else, that the court holds, at the foot of page 702, the plaintiff was entitled to treat the agreement as being at an end, as it had become obvious that the condition would not
Suspensive.
materialise. So that is a self-help remedy, rather than having to go to the court for a declaration. Yeah, thank you.
Yes. Yes, I was saying that if we look at the agreement, which is at page 173, this agreement, as I said, was signed by the proxy because the purchaser was not in Mauritius. What is important is page 176. First of all, we know, my lord, for a fact that the parties intend, we have to look at the intention of the parties. What did they intend to do on the 18th of April 2006? What was the basis of the agreement? It is clear, my lord, that there was an intention at that point in time to sell leasehold rights held by the vendor in 1993. She could only sell what she had at that point in time. And what she had was a remaining lease of 7 years. This is what she had, 7 years. And we know that the sum agreed at that point in time was 11,500,000 rupees. This is set out in the agreement. What is very important, my lord, is that the question we should ask ourselves, how did they reach that figure, 11,500,000 rupees? This is detailed in the agreement. Price, the English version price would be at page,
It's page
505.
505.
505, line 22. French would be 177. ₹5,000,000 for the rights in the lease and ₹6,000,000 for the building which was standing there. And what is more important, my lord, is that at page 507, line 31, they say that this sum, I'm referring your lordship to the fourth line, line 31, meaning 31, 32, 33, they declare that the above price represents the actual and real value of the properties. So it was the value...
I haven't found that.
Oh, I'm sorry, my lord. Page 507,
Yes.
line 33.
Oh, I'm so sorry.
So it was the actual and real price. The actual and real price as at 18 April 2006.
What do those words give us that we don't infer anyway from the agreement?
Because if you look at the judgment later on, we look at the judgment, as I said earlier on, there was an injunction case which was lodged, and the court held in that injunction case that, I'm referring your lordship to page 197 of the brief, one before last paragraph, 197. This is what the Court of Appeal says. It is agreed by one and all that as a result of the offer of the ministry to enter a new lease of 60 years, it is agreed by one and all that the premises had increased appreciably in value. And this is a judgment delivered in 1908. So 2 years later, it had appreciated in value considerably. So could we still say, my lord, that there was un accord sur la chose et le prix? Because my friend's contention is that a sale was perfected because there was an accord sur la chose et le prix. La chose being a leasehold right of 7 years, le prix being 11,500,000 rupees. Today we know that it's no more 11,500,000 rupees. And what is more, the lease is no more 7 years, it's 60 years. So can we say there is still accord sur la chose et le prix? I would say no, my lord. And our submission is that seeing that a new option had come out, the appellate wanted to have a bigger share of the cake. Because at no point in time in her plaint, she refers to any new agreement being reached. She refers to the 60 period of lease, or that authorization was not needed, or that it had appreciated in value. She doesn't say anything about those very important issues. And if you look at the judgment of the Court of Civil Appeal, the Court of Civil Appeal at page 378 finds that
Court of Appeal
378, my lord.
378, thank you.
378. Last paragraph, line 31. Thirdly, the leasehold rights agreed between both parties to be transferred under the agreement are for a period of 7 years, ending 20 December 2013. Whereas the option offered by government was for a 60-year period. The premium, the annual rent, everything was different. Last page 379, first line. Accordingly, the leasehold rights which the appellate would agree to transfer are different from those agreed upon. The court finds that there was no more accord sur la chose et le prix because everything had changed. And it is important, my lord, to look at the evidence of Mr. Chakun here. And Mr. Chakun, we know, is someone from the ministry. Page 106. 106. Sorry, my lord.
That's all right.
Line 18, so it's in the middle of the page, by Mr. S. Awaldor, my learned friend. Can you tell this court whether the ministries answered ABC, whether the condition had materialized? He said no. Then, question asked, the new lease alluded to by my friend is a different lease. Would you say from the older lease? This is the ministry's evidence. A different lease in terms and condition, yes, in terms of condition, is different from the previous one. And in terms of length, could you tell us, by way of comparison, what is the distinction? It's 60 years, 7 years, now 60 years. And the question, another question, even the price was altered, which is payable for those leases, the earlier one and the newest. The price payable was different. So, big difference. Could you help us? He says yes, only yes, but he doesn't go any further. So it's clear that we are not dealing, unfortunately, we are not dealing with the same shows which was agreed between the parties on the 18th of April 2006. Everything had changed. And it is important to note, my lord, in the face of this evidence, the trial court does not even refer at all to this very important aspect, that everything had changed. And if I'll go back, unfortunately,
and the Court of Appeal refer in that connection not only to the evidence, well, not only to the sheer delay on the part of the government and the evidence of the surveyor, but also to the letter which the first respondent wrote to the notary acting for the present appellant in June of 2006, saying that there'll be no more transfers.
Yes. I will refer to that letter to explain that this was something unilateral and did not concern the option. Let's go to page 176, which is the undertaking itself, again, and 176, and the translation is at page 504, line 31. The purchaser declares having taken cognizance and read all the conditions included in the said lease, namely Article 20, stipulating that at the expiry of the lease, the lessee will have to return the lessor the property. So she knew. It is important to know that she knew that the lease was not going to be renewed, and at the end of the lease, she will have to return the property. She knew that. She cannot claim now that she needs the 60 years lease, and for having paid peanuts for that. 7 years, 11 million, 60 years, still 11 million?
Well, I mean, the lease would expire in that relatively short time, whether consent was given to its assignment or not.
But then, if you look at the evidence of Mrs. Angteeah, that is the appellant, she said, when signing that agreement, I was taking all the risk concerned. I knew that it was for 7 years, yet I took that risk. It was a risk she wanted to take. That's why, what did she pay at the beginning? £2,000 for a lease of £230,000? Only £2,000 she paid? So she said, I wanted to take the risk. I took it. Now you cannot say, I wanted to take the risk, and now the vendor is responsible for not selling because she decided to take an option, which did not form part of their agreement. And if we look even at this is important, if we look at the particulars supplied by the appellant in this case, page 54, line 12, page 54, line 12, question 7. Was the issue of renewal of lease ever discussed at the time of the signing of a private deed? The answer is no. So she knew well that she was taking a lease of 7 years. It is important also to differentiate between those two leases, by the way. In the old lease, it was 7 years, new lease 60 years. Old lease permission was important, new lease permission is no more important. Old lease, you could not lease to a person, a third party. The new lease, you can lease to a third party. And the old lease, there was no certainty, and the new lease, there is certainty. There is certainty because there is no need for any authorization. Everything has changed. And then the price, the premium, everything had changed. So it is clear that there was a drastic change in la chose et le prix when the option was given to respondent number 1. Now, as far as the options are concerned, we know for a fact that there was a letter, my friend has alluded to that letter, which was written by respondent number 1, which is a letter found at page 184 of the brief. Translation is 509. This is Bathfield, the respondent number 1, is writing a letter to the notary, which is not copied to the other side. So it's not a letter written with a common accord in the party, common intention. It's a letter she's writing to the notary, because they decided to put everything, to formalize everything with the notary. Nothing was done without the notary's knowledge. She writes a letter to him saying that there is a possibility that there won't be a follow-up of new leases. But this is letter written on the 13th of June 2006. At that point in time, the options were not out. So it is clear that at that point in time, she does not know that there was going to be a new lease of 60 years. She doesn't know that authorization will no more be needed. She writes the letter in good faith 2 months after the signature of the undertaking. She wants to go along with the undertaking 2 months after that. She doesn't want to back out. But then she says, last paragraph is very important. And if we look at page 509, last paragraph, could you please, she's writing to the notary, could you please, he's a legal person, he knows that he can help them. I'm asking for help, I'm confused. Could you please keep me informed or make any suggestion that would materialize the sale to the satisfaction of both parties? This is what the letter shows. This letter doesn't show that she was ready to go into a new agreement, that she was ready to take up a new option, that she had decided to proceed with a new option, or there was an accord on the new option. This is a letter she writes to say, suggest what do I do? But she does not know that there is an option yet. We know that there is an option which comes on the 19th of May.
Can you help me with what
Yes.
the middle part of this? I'm looking at the English translation on 509, but by all means do it in
Yes,
French.
yes,
It'll be more. She says, not having the means to subscribe to the conditions of new leases included in the budget, the solution that would benefit both parties, the Guillermic and myself, would be to deduct from the sale price the amount due from the new lease.
Yes, yes. But she's not...
I'm trying to understand what she's contemplating. Is she thinking that she will transfer the old lease to the purchaser and accept a reduced purchase price to enable the purchaser to pay the premium? Well, what is she saying?
It's very confusing what she says, because we don't, and what is important, the notary who drafted the agreement, to whom the letter was addressed, doesn't come to court to explain all that. Oh, no, what I'm saying... I
thought he did come to court.
No, but he didn't explain the contents of this letter.
Nobody asked him what he thought it meant.
He was not asked about the contents. So can we now interpret what she wanted to say in that letter today in 2019? Because we don't know. And what is important, the trial court does not refer to this letter. It was not made a live issue in the pleadings. The trial court, if we look at the judgment of the trial court, he doesn't refer to the letter of the 13th to say that there was a new agreement. It is very important to note, my lord, that in the judgment of the trial court, at no point in time does he say there was a new agreement reached between the parties. He never says there was a novation. He never says, if you read the letter of the 13th or the letter of the 29th, that parties had agreed to enter a new agreement. For we know for a fact the agreement, if they wanted to enter into a new agreement, it would have been done before the notary. Because all the letters were sent to the notary, the undertaking was drafted by the notary, the letter of authorization to the government seeking permission was written by the notary, the parties sat back, the notary did everything. So can we say that this letter shows that she wanted to take the new option, or she wanted to give a new option to the appellant? No way, my lord. Because the option came in 2007, and she's writing a letter in 2006.
The Court of Appeal regarded it as material, I think, to the parties being aware in 2006 that the condition was not going to be satisfied.
Yes, my
lord. The condition in the original agreement.
And if we look at the judgment of the trial court at page 37, at the Court of Civil Appeal, I'm sorry, my lord, 378. This is very important. Line 12. Mr. Glover submits that by letter of 13 emanating from appellate, it is to be inferred that despite the changes in the policy, the appellate still intended to transfer the lease. In other words, she had renounced the condition suspensive. But then the court says this is not correct, because when you have to read the letter in its entirety, and it says, line 24, however, there was only a proposal from the appellate who ended her letter by inviting the notary to make suggestion for the perfection de faire toute suggestion qui permettrait de conclure la vente de mon campement à la satisfaction des parties. Now, what is shocking, my lord? The notary never writes. He doesn't give any suggestion to the parties. Because he knows, he drafted the agreement, he knows this is not part of the agreement. That's why he doesn't suggest anything. Because he knows the parties, the common intention of the parties was to be gleaned from the undertaking dated 18 April 2006, and that had not changed after that. That's why the notary, we know he doesn't write. After a year, he doesn't write. When does he write? He writes after a year, on the 29th of May 2007, page 190, my lord. Page 190. And why does he write? He writes to inform her that government has given a new option, 190, my lord, which is the translation at page 510. Yes? So he writes to inform Mrs. Bathfield, respondent number 1, that government, I have received a letter from government, because the option was sent to to the notary, Mr. Leblanc, and not to Mrs. Bathfield, respondent number 1. And he says, I have received a letter dated 19th of May. This is the letter found at page 186. But then, unfortunately, the letter is not complete. The option which has been filed in court is not complete, because we don't have the conditions. Page 186 to 189. And then he relates what Mrs. Angteeah, the appellate, told him, that there is supposedly an agreement which was reached. When was the agreement reached? Sometime in February 2007. But my lord, we know that Mrs. Angteeah, the appellant, came to Mauritius in February 2007. She came to Mauritius. If there was such an agreement, would she not have gone to the notary and told the notary, see, Mrs. Bathfield and myself have reached an agreement, let's finalize everything now? She doesn't do that. She was in Mauritius, we know, in February, because if I can refer your lordship to the relevant page where she says, I am in Mauritius in February.
The critical difference between the Court of Appeal and the Supreme Court appears to be that the Court of Appeal considered that the suspensive condition had défailli, had lapsed,
Yes.
And therefore there was no breach or waiver of the condition or any prevention of its fulfillment by the present respondent when she entered into the new arrangement with the government.
Yes, my lord.
Because the condition had already lapsed.
Yes.
Whereas the trial judge
says there was a continuity. The trial judge, in fact, if I may, my lord, he lumps the agreement and the option. He doesn't make the distinction between the agreement and the option, because these are two different things altogether. But he lumps them. He says she is to be blamed because she took the option as late back as October 2010. But she is not to be blamed. did she at any point in time prevent the fulfillment of a condition when it was signed? She did not. And we know for a fact, my lord, that if she does not take up the new lease,
Well, we know she was being...
she would be bound by...
alleged to be in breach of contract in not taking it up as well. Yeah.
And if she does not take the new lease, what would happen? I'm here referring, your lordship, to the lease agreement, which is the one dated 23rd of October. It is important to note, my lord, that on the 23rd of October, 205, page 205, page 205, this letter, it revoked the first option. And we have no indication that the respondent number 1 was given a copy of that option. Page 205.
23rd of November.
Yes. If we look at page 207, we know there is a letter sent by the notary, but there is no attachment in the letter. So, page 207, paragraph 16. If no option is received from you, as provided at paragraph 14, within a period of 6 months, you will deem not to have accepted the lease. You will be governed by your own lease. It's not that Mrs. Angteeah is going to lose everything. She is still going to be governed by the old lease, and the old lease means authorization is mandatory. And as I said earlier on, there is no evidence that there was a new agreement reached. At any rate, in the letter of the 13th of June 2006, there is no mention of the new conditions. My lord, how then can the parties reach a new agreement if they don't even know what are the conditions? It's impossible. And then I'm going to have to refer back to the letter of a notary, which is at page 190. Translation is at 511. If you look at page 511, my lord, the top of 511, the notary is asking Mrs. Bathfield, could you please in return confirm me by fax whether the contents of this letter are okay and if it reflects your agreement? My lord, if there was an agreement, would he have asked this question? It means there was no agreement. It means there was no change in the undertaking. The notary, again the one who was appointed by both parties, is asking the respondent number 1, do you agree with what Mrs. Angteeah is saying? Let us know whether you agree, showing there cannot be any accord. The legal person is asking that question. Tell us if there is an accord. And then, if you look at the same letter, my lord, page 190, last line, and translation 510, last paragraph. Furthermore, Mrs. Guillemik has also informed me that as soon as the government would give its consent to the transfer of the lease in her name, which shows, my lord, that the question of new option could not have arisen because she is still talking of the authorization to be given by government. And we know for a fact that in the new option, authorization was not necessary. So it is clear that Mrs. Angteeah herself is saying that once we get the authorization, we will pay, we will sign the deed, showing that she is not aware of the option. There was no agreement of the new option. And at any rate, the letter is written on the 29th of May, and the option which was given on the 19th of May was revoked in the subsequent letter, which was written on the 23rd of May. This is page 205.
Could I ask you, please, just to assist me with this?
Yes, my lord.
Your submission is that the opportunity to secure consent for the transfer at some point fell away. It was perfectly clear that it would not ever be given.
Yes,
when do you say that was? What would be your deadline for that, or your long stop?
Yes, if the purchaser was given 15 months to back out, the same should have applied to the vendor. But then, 18 months after the signature, the purchaser lodged the action. So there was already an issue between the parties, if I may say. Because she breached all the amicable relation that was between them. So if she had 15 months, why would I have 20 or 60 months? I should get same. There should be fairness in an agreement.
The approach of the Court of Appeal of Montpellier in the case that we were referred to was to treat this, the answer to this question as essentially depending on the parties' intentions, and to say that they can be taken to have intended that it would be the normal period, a normal and reasonable period, which in the circumstances of Montpellier, or Perpignan I think it was, they said that a year would be largement suffisant.
Exactly, my lord.
In Perpignan. Now, conditions in Mauritius, I suppose, aren't necessarily the same as in Perpignan, but one assumes the local court, the local judges would have a good idea of what would be a normal and reasonable period of time.
But we are guided by French law in matters of contract. And if the court says there 1 year is good enough, anyway, we could have, let's go beyond 1 year, 15 months. You are given 15 months, I'm given 15 months, or even 18 months. But
yes.
Not 2 years, 3 years, 4 years. Because the authorization was given in 2010.
Yeah, it certainly can't be any less than 15 months.
Yes, it can't be less.
But on any view, it's less than, whatever it was, 4 years.
It can't be less than 15 months, but we should not forget, my lord, in February 2007, we have evidence, in February 2007, the parties go to the ministry. It's not like Mrs. Bathfield wanted to back out, or she saw that there was a new agreement and suddenly she became greedy. She went to the ministry in February 2007. She's asking the ministry, please speed up matters. And they tell her it's going to come in 3 to 4 weeks. 3 to 4 weeks wouldn't be March. It never came. In fact, it never came. The permission was never given.
Can I just go back to page 510, which is
Yes,
the
my lord.
English translation of the letter from the notary of the 29th of May. If one reads the last two paragraphs together as all part of the same discussion, is the notary therefore not saying in the last paragraph that, well, taking the two paragraphs together, she'll use 1.5 million rupees of the 5 million to be paid on account of the purchase price up front to get the new lease, which will then be transferred to the purchaser. And then the purchaser also told him, as soon as the government Mauritius will give its consent to the transfer of the rights of the lease, that must mean, I think, in the context of the new lease, then she will pay the balance.
But in the new lease, there was no need for authorization.
Well, yes, but I'm not sure anybody knew that at that stage, or at least they're not sure that well, whether Mrs. Guillaume knew that, it may be that that's what maybe the notary would have assumed, that if there was no restriction on transfer, then the grant of the new lease would be authority to transfer.
If there was if they don't know the new conditions, my lord, how can there be accord sur la chose pris? They don't even know what are the conditions.
But presumably there was no thought that even if there was a restriction on transfer, that the government would suddenly start refusing transfers if it got what it wanted, namely the substitution of a very old lease at a low rent with a new lease at a modern rent, even if they didn't know whether it contained a restriction. As I understand it, the attorney's evidence was the government never refused transfers in the past. They were refusing transfers at this time because they wanted everybody to take new leases. But would there be any reason to think they'd refuse their transfer once a new lease was granted?
We don't know whether it was going to be refused. We don't know.
No, we don't know.
There is no. What is important, my lord?
I'm just trying to understand what
Yes.
he's...
If you look at this letter of the 29th, if we look at the second paragraph says, in order to give effect to the agreement reached, the notary is saying, in order to give the effect to the agreement reached between you and Mrs. Guillemette. He's talking about a previous undertaking. He doesn't mention, he's saying, Mrs. Guillemette told me that there was such an agreement. When was that agreement? We know for a fact when she wanted to explain that agreement, there was objection on the part of my learned friend. I'm going to refer your lordship to that paragraph. I think my friend has already referred to that evidence of Mrs. Angteeah. Because we shouldn't forget, my lord, that she does, at page 123, this is important, page 123.
But I'm sorry, just before we go to 1, 2, 3, you were taking us to the translation of the letter. I just wondered, could I ask you to comment? I'm not, it seems to me it may not be a very accurate translation. If you look at the third paragraph,
Yes, my lord.
you'll see the verbs, by virtue of which agreement you had accepted. Mrs. Guillemette shall have the right.
This is what Mrs. Guillemette is saying.
You have undertaken to accept, and so forth. Now, if you look at the original in the French, which is on page 190, au terme duquel vous accepteriez.
Yes, which is in the future.
And it's a future conditional.
Yes. It's not a correct translation. In fact, it distorts it.
Madame Guillemette aurait droit.
Yes.
Vous vous engagiez à accepter. So there's a compared with the English, the whole thing is being put in a conditional mood rather than an indicative mood.
Exactly right. Exactly right.
It's an agreement made, but thereafter all the verbs are in some kind of future.
Yeah, a few.
It's a nouvel accord passé entre under which you would accept.
You would accept. You would do.
She would give you the enjoyment of the bungalow. Aurait droit à
she would be entitled to the enjoyment of the
Yes.
And vous serez fait par le gouvernement.
Yeah, and you would engage to accept the offer which the government had made. Yeah, thank you.
Yes, my lord. And I was referring to, I was submitting at page 123, that at no point in time does she explain that novation, that change in agreement in the evidence. In fact, she was prevented to do so at page 123. And the court says at line 8.
Page 123. I beg your pardon, which page?
Page 123. 123, my lord.
Yes.
Mr. Awaldor says there is nothing to show any kind of discussion. Then the court says, I take it Mr. Glover doesn't want to lead the witness on the contents of the agreement. Then Mr. Awaldor says, as far as he doesn't. Then the court says, we'll have to wait for her answers. And she never explained that new agreement. Nor is it averred in the plate with someone, and she doesn't even explain in court what was that new agreement. And we know for a fact, my lord, if there was such an agreement, the sum of 5 million was never paid. No, if Mrs. Angteeah was really, really of good faith, and if this really happened, we would have expected her to go to the notary, deposit 5 million rupees to show her good faith, to say, see, I'm depositing 5 million rupees with you because there is an agreement reached between me and Mrs. Bathfield to the effect that she's going to take that money to pay the premium and that she was agreeable to the new lease. She doesn't do that. Nor does she send a mise en demeure to Mrs. Bathfield saying, see, you've reached a new agreement now. Come and pay. Come and sign the option. But what is important, my lord, she does send a mise en demeure in 2008, May 2008. And that is at page 2 to 3 of the brief. And in that mise en demeure, which was lodged after the case, which was set after the case was lodged, page 223, at page 2 to 4, what does she say? Now that the parties have already gone to court, she is saying, take up the option. Before that, my friend seems to be suggesting that because she took the option, she prevented the agreement from being perfected. But she's asking to take the option herself. And it was in 2008. And in that mise en demeure, she had the latitude, my lord, to come and explain there was a new agreement. Mrs. Bathfield was willing to give the keys. Mrs. Bathfield had agreed to take 5 million rupees. Mrs. Bathfield and I had reached a new agreement. There was no more authorization needed by that point in time, because by that point in time, she knew there was no more authorization was not needed, because we are in 2008, and the option was given in November 2007. She doesn't do all that. She had the opportunity of doing that at that point in time.
Now, Ms. Munshiram, can I just interrupt you for a moment just to make sure you're going to allow sufficient time
Yes.
for Mr. Casey to make submissions on behalf of the co-respondent?
Yes, ma'am.
I presume that you have discussed amongst yourselves how long Mr. Casey requires.
Maybe one loss. I'm going to refer to the agreement again, finally.
Because
Yes.
there's about 20 minutes left of the slot allowed for you and the co-respondent together.
Yes. If your lordship is minded, I could only refer your lordship to the case of Kuwa Jabu, which says that if there are conditions suspensive in a contract,
Yes.
then the sale cannot be perfected. I can refer to the tab only.
I don't think that's in dispute. But
Is it not in
if it's properly categorized as a condition suspensive, then the sale is not perfected until the condition either is satisfied or is défailli.
Yes.
But,
And at page 177, where it's written condition, it's clear that there were three conditions. That's why it's written in the plural, not in the singular.
Yeah.
Condition essentielle, with an S.
Yes.
To show that the three were essential conditions, not only one, the three of them, because it's given under the same heading.
yes.
Because my friend seems to be suggesting that there was only one condition which was essential. Three of them, condition with an S, written by a notary, so it was not one condition. Maybe, my lord, I should end my submissions to give my friend time to respond.
Well, you can take it that we will take account of all your written submissions in addition to what you've said in your oral submissions.
Thank you, my lord.
Thank you very much. Mr. Casey.
My lady, as you will have seen from the Ministry's case, we have sought to participate in the appeal only upon the question of whether or not the relevant condition provision in the contract is properly characterised as a condition suspensive or a terme suspensif.
Yes.
And you may have seen reference in our case to the fact that this is important to the Ministry, because although the regime, as it were, is changing in relation to communal site leases, there are many other types of lease in existence which continued to contain prohibitions on assignment without consent.
Yes.
And so the Ministry is concerned to see that clauses then reflecting those clauses in assignments are not in any way watered down or misunderstood.
Yeah.
In our submission, in order then to approach that question on a correct footing, one has to, in fact, break the question down into two elements, which we have called the subordination question and the certainty question in our case. And so the first question we would say is, as a matter of analysis or interpretation of the relevant contract or instrument, can it be said that the parties intended to subordinate the obligation to the happening of the event? And we say that if that element is fulfilled, then so long as the event is on analysis uncertain rather than certain, one's dealing with the condition suspensive. Now, I apprehend from the argument today, of course, that may not be the end of the question, and there may be many other elements of dispute between the parties, but those are not areas into which the Ministry goes to trespass. Now, on the footing that, as I think is right, it's common ground that if one is dealing with a condition suspensive, then that has certain important effects, including that essentially the obligation hasn't come into life, as we're trying to translate it from some of the French jurisprudence on these. We would submit that on the subordination question, looking at the provision one's dealing with here, this is on authorities to be treated as a question of analysis of the parties' intentions, but to be gathered from the contract itself. Now, my lady Arden, I think, adverted earlier on to the actual use of the word in our case. Subordinate. We submit that that is relevant, and one might just go to one of the authorities. It's Annandon and Benoit at tab 25. Begins at MS page 790. And one can pick up the key facts, I think, from the opening paragraph on that page. That Mr. and Mrs. Benoit had undertaken to sell to Mr. Annandon the relevant property. Then over the page, foot of page 791, the final paragraph. The respondent's case was that they was on express understanding that they would be paid the total amount for the sale of their property by 31st of March 2009 at the latest. Denied having been paid the relevant sum as averred by the applicants, although they had cashed a down payment. They then say that they had agreed an extension of time out of good faith, submitted all the required documents to the notary, and then to their dismay were informed that the applicants, the buyers, were not in a position to give them the remaining amount due, and they'd have to burden their property with the caution hypothecaire in order to enable the applicants to secure a loan for the settlement of the remaining sale price. And so this was then an application by the applicants for a writ of possession of the property in those circumstances. So slightly unusual in that the applicants hadn't paid the full price, but those are the circumstances in which the dispute arose. And the relevant passage that we pick up is over on page 792. One sees their reference firstly to the article 1589 of the Code Civil, which promised to belong to Beaumont, then a citation from Dalloz, and the underlined words at the end, that lorsque les parties au contrat préparatoire ont exprimé clairement leur intention commune de reporter ou de subordonner la formation du contrat définitif à l'accomplissement de cette formalité, la promesse ne vaut pas vente. So that is, if you like, where one of the authorities from which one gets the use of the concept of subordination, which we think is important when one looks at the instrument in our case. And then, as to the fact that one gathers the intention from the instrument itself, you may have seen a number of references to the Bowler case, which is at tab 27. Page 806. That's where the case commences. And in this case, one can pick up the essence of the factual or the circumstances which gave rise to the dispute from the penultimate paragraph on page 807. The defendants had averred that the proposed sale was subject to the defendants purchasing another house for their use and occupation, which purchase was expected to materialize at a particular point in time. And that according to the defendants, the authentic deed would only be signed when the new house was acquired. So that, if you like, is what gave rise to the issue in this case as to whether there should or shouldn't be an order that the sale be effected. And the reference to which we would draw attention, firstly, we'll get to page 810. Top half of the page is summarised, if you like, what we've heard today as to the significance of a promesse de vente if there's agreement upon both le prix and la chose. Then at the foot of the page, 3 lines up, in the present case, the tenor of the agreement reveals clearly that there was a consentement réciproque des deux parties sur la chose à vendre et sur le prix. And then really the meat of it for these purposes at page 814, where we'll get the citation from Dalloz. And 162, really, the opening words of 162 of Dalloz in this passage. La réponse à la question ici posée ne peut être livrée que par l'intermédiaire de la commune intention du parti, à travers l'interprétation du contrat préparatoire. So in our submission, on the authorities cited by the parties and before the board, what one is doing in considering the subordination question is simply looking at the contract and saying, well, was there not an intention to subordinate the relevant obligation to the happening of it? Yeah. And we say that deed here really admits of only one construction in that regard. The words we've looked at page 506 expressly talk of subordination.
Yes, at times during the discussion today, I think one might have wondered, or might not have been entirely clear, why it mattered whether we were dealing with a terme suspensif or a condition suspensive. But in fact, if I've understood where we've got to, it's absolutely fundamental, because if it's a terme suspensif, then it can never lapse. It's going to be fulfilled sooner or later, and that's what you've agreed to. If it's a condition suspensive, on the other hand, it's uncertain of fulfillment, and therefore is capable of lapsing after a reasonable time has passed, if that's the intention that can be attributed to the parties.
Absolutely, yes. So if one has, as it were, subordination, but an event which is certain to happen at some point in time, then of course one can't say, well, a conventionally sufficient time has passed for that event to happen, ergo I should be released. And one sees a common example given in the authorities is the death of a named individual.
Yes.
Logically, with that argument simply can't run.
Yeah.
But as it were, in terms of what interests the ministry, then we submit this is a clear case of subordination, and it's a clear case of uncertainty. because albeit that past experience suggested that the ministry was very lengthy, as long as the ministry was not somehow bound to grant consent, it can't be said that it was a logical certainty that at some point it would do. And if that's right, then we submit the judge was wrong when he said that the term could either be characterised one way or the other, which is how he expresses himself at one point, and to characterise the term as a term and not a condition. Well, that's really the extent of the ministry's interest in what's otherwise a very interesting case. So unless my lords, my lady, have any further questions for me, I'll make room for Mr. Glover.
Thank you very much indeed, Mr. Casey.
Could I just ask one thing?
Yes.
Would it be accurate to say that a condition suspensive forms very much the same role as a condition precedent?
I think that's, for many purposes, very, very, very accurate. Yes. There may be difficulties in drawing too close parallels.
Absolutely.
But that's essentially as I understand it, yes.
Thank you.
Thank you. Mr. Glover.
Yes, my lords. Lords, I will start with the remark of your lordship in regards the importance of making the distinction between the terme suspensif and the condition suspensive. It has been my submission this morning that even if it were a condition suspensive, at the end of the day, given the facts and the law in the present circumstances, the Court of Appeal erred in their appreciation of the facts and the evidence, and erred when they reversed the verdict of the juge du fond, who had the opportunity of hearing the witnesses and making a decision as to the facts which had been elicited before him. Now, there are a couple of issues that perhaps need to be cleared up. One of them is the reference by my learned friend to document H, which is the judgment of the Court of Appeal, the Supreme Court sitting in its appellate jurisdiction as opposed to the Court of Civil Appeal, since it was a judgment, it was an appeal from the learned judge in Chambers, where my learned friend took the board to page 200, to MS 200. And she read from the last paragraph of that judgment, where it is written, it is patently clear that the interpretation given by the learned judge is the right one, where it is, while it is a correct proposition law that appellant number 1, which was Mrs. Bathfield, cannot be bound for life to maintain her undertaking to sell the premises to the respondent if no approval is forthcoming to effect the transfer, it is certainly up to the vendor, the appellant number 1, to invoke any refusal from the suite, which she has failed to do. If she wants to seriously invoke the event of a condition suspensive pursuant to 1181 and following, we have to point out, in any case, that the issue of condition was never raised specifically before the judge in Chambers. And therefore, it supports the contention that if the vendor would wish to render her obligations to have terminated, it was for her to take the case to the courts under 1184 in order for have it to be declared unreasonable. Because at the time of the decision as to what point of time is it reasonable or unreasonable, we've had discussion about whether it's with 12 months, 15 months, 18 months. No one in this room can say in what particular case a particular delay would be deemed to be reasonable. It must be left to the juge du fond to appreciate that fact. And that is why the mechanism exists in the civil code for the party to go to the court and say, well, declare that it is now unreasonable for me to be bound eternally by this undertaking of mine.
Yes, but in the present case, the judge, not having treated this as a condition suspensive at all, the first court to do that was the Court d'Appel, was the Court of Appeal.
Yes.
And they, therefore, were in a position to make a finding as to whether or not the time that had elapsed was such as to render the condition défaillie.
The point is exactly this, my lord, and you've hit the nail on the head. The fact of the matter is that, as I said, even if it were a condition suspensive, is it the case in the present matter that the Court of Civil Appeal decided that because of the undue delay which had lapsed, it was thus that the condition had défailli. That is not the decision of the Court of Civil Appeal. The Court of Civil Appeal finds on the facts that it had become certain that it would not be forthcoming, which is a totally different proposition, isn't it? And that's what we say. We say we are attacking the Court of Civil Appeal when it says that on the evidence, there is enough evidence to show that the clause had défailli by reason of the fact that it had become certain on the evidence that it would not be forthcoming.
Well, they say at page 377.
I'm sorry, my Lord.
At page 377.
Yes, my Lord.
Line 23. In the result, since the authorization from the ministry was never obtained, the condition suspensive had not been fulfilled.
Yes.
And over the page, line 3, the condition suspensive is deemed to have défailli in terms of Article 1176.
Yes. In both instances in that judgment, my Lord, in that those two quotations which your Lordship referred to, it is clear that the learned judges are saying that it had become certain that it would not be forthcoming. I'm asking, where is the evidence to sustain that finding?
Well, they refer to the evidence of Mr. Chukun that as a matter of policy, the government wasn't extending existing leases, and to the sheer fact of the delay, and to the letter that the appellant wrote to Monsieur Leblanc informing him that there would be no transfer of the leasehold rights.
My Lord, you are referring to page 372,
Yeah.
are you not, at line 13 and following. Yeah, where the evidence of Mr. Chukun is analysed by the Court of Civil Appeal, and the important part is the fourth line in that paragraph. His testimony is to the effect that on account of the intention of government announced in his budget to introduce a new campement tax and new measures to regulate the patrimony, the ministry was not considering applications for transfer of leases. The government was planning to introduce new policy in relation to these. That evidence, that finding by the court is not supported by the evidence. I have highlighted in my submissions earlier on the points made by Mr. Chukun when he deposed, and I said that Mr. Chukun had given a number of points where he had said, for example, that... What?
Yes, you took us to this morning.
Yes, that they were not looked into, and these were the words used by Mr. Chukun in his evidence, and that in cross-examination, my friend Howeldahl put him the question, do you mean that they have been frozen? And he said, yes, they've been frozen for the time the policies were being implemented. And when we read that in conjunction with what the new options say, which mean where the new options say, if you don't take the new option, you will still be governed by the old conditions of the old leases, and beware, at the end of these old leases, we will apply in the full rigor of the clauses which pertain to that old leases, i.e. we're going to take the property back from you.
Yeah. Yep.
So that was the second point. Now, in relation to Tamarind Falls, my Lord, which is referred to in the judgment of the trial court, at 159, and which is also at tab 12. My learned friend has made a point to the effect that this is a case on all fours, and I beg to differ. this is a case which is not an all fours, because in the Tamarind Ford case, the plaintiff was the vendor and the defendant the purchaser. And why the vendor had to enter the cases was precisely because the defendant was sitting on the land, had constructed buildings thereon, and therefore was claiming that it would not use the exit clause that was open to it and would therefore stay on the land. Now, it is very important to see this judgment of the Court of Appeal, because whilst finding that the condition, and I take you to MS 701.
Sorry. Page
701.
of the authority.
Yes, of the bundle. I'm sorry, my lord, yes. I was talking about the judgment of the learned judge.
Yes,
And then
thanks very much. Yes, thank you.
Penultimate paragraph. They treat the agreement as though the power reserved to the defendant to decide on the nullity of the deed did not exist because of the fact that it is illicit. And we turn the page. At the top of the page, it's line 2. 2 years after signing the deed, the plaintiff was still clamoring for his permit, and here we have the defendant, nearly 4 years later, suggesting he should keep trying. Next paragraph, third line, the question therefore is, did they intend to allow matters to drag on indefinitely, or at any rate, is the defendant entitled, asked the plaintiff, to go on waiting for the elusive permit? And further down, once it is accepted, as we do accept, that the refusal is now definite and might resolve itself into a question of costs, the conclusion at the bottom of the page, we accordingly hold that at the time it entered the present action, the plaintiff was entitled to treat the agreement as being at an end, as it had become obvious that the condition suspensive, namely obtaining the permit, would not materialize. We find support for this in the following notes from the decision referred to, and this is the quotation that the learned judge uses in his judgment at first instance. And they accordingly held that the defendant could not hold the plaintiff at ransom in view of the fact that it had become certain, and there the evidence was there, that it had become...
Yes, but they say it hadn't become certain until the government actually took the decision.
Yes.
And that was after the proceedings were raised. And that's the point of it's being made at the foot of the page. The plaintiff was entitled to treat the agreement as being at an end. At the time it entered the present action, the plaintiff was entitled to treat the agreement as being at an end. In other words, before the government actually took any decision, the plaintiff was nevertheless entitled to treat the agreement as being at an end, as it had become obvious from the sheer lapse of time that the condition would not materialize.
My Lord, I do agree with that reading of the judgment. It is abundantly clear that this is exactly what the learned judges say. Yeah. But the fact of the matter is that, again, here we have, as your Lordship rightly pointed out, clear, unobtrusive evidence that it would not materialize, despite what the learned judges term the clamoring of the plaintiff asking for his permit.
Yes, but in the first complete paragraph on that page, halfway through it, they say that the government's decision to refuse the permit was made in 1976, that is, well after the action was entered. Can it therefore not be said the plaintiff's suit was premature? And so they then go on to deal with it.
That is a question of academic interest and will be dealt with in the question of costs. This is what the learned judges say. We have no quarrel with that, my Lord, because of course a decision in itself would put everyone at ease, because then one would know what is certain and not certain. Yep. The difficult situation is when we do not have a decision, like in our case, to decide whether it is certain or is still uncertain. And this is this is where le pouvoir souverain du juge du fond kicks in. And until and unless he makes a wrong decision on that score, he cannot be faulted. Now, I hear your lordship when your lordship refers to the two passages in the Court of Appeal judgment. Which is as 370 and following. Your lordship was referring to 377 and 378 and 379, where the learned judges write, in the result, the authorization was never obtained. Now, that must be read in conjunction with the previous paragraph, my lord. And this is where I think the learned judges erred. They say the learned trial judge referred to revealing statement by Mr. Leblanc, who stated that during a long career, and he and his father he has not known of a single case where the minister's permission was refused. However, the fact remains that the authorization was never a certainty, as subsequent events clearly demonstrated. On account of a change in government policy, the authorization was not obtained. Mr. Chucken referred also to several other applications for transfers which were not entertained, which were not looked into, which were not entertained, and on which no decisions had been taken unless and until all these lessees had decided whether they were going to take the option or not. That's a long stop date referred to by Lordship earlier on in the discussions. Yeah. So, although Tamarind Falls, the decision in Tamarind Falls would seem to be an all fours, it is certainly not, because we had ample evidence in the Tamarind Falls case, which in our case say we didn't have. And clearly here, whereas in the Tamarind Falls case there was no policy, no clear reason why the decision was not forthcoming, here we have a reason. And that reason is simply the policy implementation by government following the 2006 budget. And on that score, my lord, may I take your lordship to tab 6 again? It's very important for your lordship's understanding. Now,
it didn't have to be this change in policy. At the time when the parties entered into the agreement, was it not then a realistic possibility that the government might change its policy as lessor on giving consents?
At the time the agreement was reached, document B was whether it was possible that the government was going to come with a change. Milady, yes, I think that there was a possibility, that it was rather nebulous at the time. Mm-hmm. And it is only when the budget speech came in June 2006, that's why the letter from Mrs. Bathfield is in June 2006, that was when the budget speech was aired. And then the debate, number 27 of the 26th of July 2006, this is where we know that there is going to be a 60-year lease. We know that there was going to be a premium. We know that there's going to be a revised rental. We know that those who do not accept the offer may continue on their present lease on the same terms and conditions. However, at the end of the lease period, I read from the second paragraph, last two lines at MS 660, however, at the end of the lease period, the relevant conditions as contained in the lease agreement signed between the two parties shall apply. Then they actually give the prices, how much it's going to cost. We know from that document what is the premium that Mrs. Bathfield is going to pay. And that is why in May 2007, when the first option comes up, Mr. Leblanc can say in his letter the premium would be approximately 1.5 million rupees. And it found, in fact, it was 1.493 million rupees, as the evidence of Mr. Chucken reveals. So, my lord, it is therefore our submission at the end of the day that this case will rest or will be won or lost on the basis of the decision of this board as to whether the Court of Appeal was right or wrong to reverse the judgment of the trial judge not only on the question of whether it was a term suspensive or condition suspensive, but even conceding that it was a condition suspensive, whether the evidence which was adduced before the trial court was enough for the Court of Civil Appeal to say that there had been a misapprehension of the evidence and a wrong application of the evidence to the law as it stood. These will be my submissions, my lords.
Thank you very much indeed, Mr. Glover. Questions? Well, we're very grateful indeed to all counsel for their submissions. This is an interesting case and obviously one of some importance. We'll take time now to consider all the submissions that have been made, and in due course the board will issue its judgment.
Thank you, my lord.